Clarence Thomas is an American judge, lawyer, and government official who currently serves as an Associate Justice of the Supreme Court of the United States. He was born in June 1948, and therefore he is now 70 years old. And he's currently the most senior justice on the U.S. Supreme Court, following the retirement of Anthony Kennedy earlier in 2018. He succeeded Thurgood Marshall, a fellow African American, but whose judicial philosophy was almost diametrically opposed to that of Clarence Thomas. The late Associate Justice Marshall was a liberal Democrat, while the current Associate Justice Clarence Thomas is clearly a conservative Republican, and as such, quite a rare African American still in public life in the United States. He has now served in the U.S. Supreme Court for almost 27 years, since October the 18th, 1991. He grew up in Savannah, Georgia, and was educated at the College of the Holy Cross and at Yale Law School. In 1974, he was appointed an Assistant Attorney General in Missouri, proceeding to practice law there in the private sector. In 1979, he became a legislative assistant to Republican Senator John Danforth of Missouri. In 1981, he was appointed Assistant Secretary for Civil Rights at the U.S. Department of Education. And in 1982, President Ronald Reagan proceeded to appoint him chairman of the Equal Employment Opportunity Commission. In 1990, then President George Bush nominated Thomas for a seat on the U.S. Court of Appeals for the District of Columbia Circuit. On July the 1st, 1991, following Thurgood Marshall's resignation due to advanced age and poor health, President Bush appointed Judge Thomas, or nominated Judge Thomas, to fill Marshall's seat on the United States Supreme Court. His confirmation hearings, contrary to or largely contrary to those of David Souter back in 1990. Souter was almost unanimously confirmed, by the way. This information comes from Bob Woodward's book Shadow: 5 Presidents and the Legacy of Watergate. Thomas's confirmation hearings were bitter and intensely fought, centering on an accusation by law professor Anita Hill, who had been one of his subordinates at the Education Department and subsequently in the Equal Employment Opportunity Commission, that he had sexually harassed her, although in verbal terms, never making unwanted sexual advances physically. Despite the fact that she, according to her testimony, had repeatedly rebuffed him and had told him to stop such overtures. Thomas and his supporters claim that Hill, witnesses who came forward on her behalf, and her supporters had fabricated the allegations to prevent an African-American conservative from getting a seat on the U.S. Supreme Court. When all was said and done, the U.S. Senate, very narrowly by a vote of 52 to 48, confirmed Justice Thomas. Since joining the U.S. Supreme Court, he has taken a textualist approach, seeking to uphold the original meaning of the U.S. Constitution and statutes. He is also, along with fellow Justice Neil Gorsuch, an advocate of natural law jurisprudence. When Associate Justice Antonin Scalia was still alive, he passed away in February 2016, apparently of natural causes, while visiting Texas. At least according to some news commentators, he and Clarence Thomas were probably the two most conservative justices in the 9-member U.S. Supreme Court. And he is now, according to his Wikipedia article with Wikipedia biography, generally viewed as the most conservative member of the court. He also is known for almost never speaking during oral arguments. His first spouse was Kathy Ambush. They got married in 1971 and divorced in 1984. He then married Virginia Lamp, a white American conservative Republican political activist in 1987. He has one child. And interestingly also, he is a Roman Catholic. Having spoken the so-called Gula language as a child, he realized in college that he still sounded unpolished despite having been drilled in grammar at school, and he chose to major in English literature to conquer the language. It is one of the dialects traditionally spoken by African Americans in the United States, especially in southern United States. So his Supreme Court nomination became very ugly. I'm old enough to remember hearing and seeing reports of it, especially reading reports of it in the Canadian media. I was still living in Canada as an immigrant. Toward the end of the early hearings, National Public Radio's Supreme Court correspondent Nina Totenberg received a leaked or unauthorizedly published Judiciary Committee and FBI report that a former colleague of Thomas University of Oklahoma Law School professor Anita Hill had accused him of making unwelcome sexual comments to her when the two worked together in the Department of Education and later in the Equal Employment Office Commission. In the same FBI report, Thomas testified that he had once promoted Alison Duncan over Hill as his chief of staff in the Equal Employment Office Commission, or Equal Employment Opportunity Commission, sorry. On October the 11th, 1991, Hill was called to testify during the hearing. She said that she was testifying about Thomas's character and fitness to serve on the U.S. Supreme Court, and was ambivalent about whether his alleged conduct had in fact risen to the level of being illegal sexual harassment. In 1981, she had become an attorney advisor to Clarence Thomas in the United States Education Department. When Thomas had become chairman of the U.S. Equal Employment Opportunity Commission in 1982, Hill had gone with Thomas to serve as his special assistant until she had resigned in mid-1983. Hill had alleged in her 1991 testimony that it was during her employment in the Education Department and the Equal Economic Opportunity Commission when Thomas had made sexually provocative statements. She testified that she followed Thomas to Equal Employment Opportunity Commission because the work itself was interesting, and at that time it appeared that the sexual overtures had ended. She also testified that she wanted to work dealing with the civil rights, and that she believed that at that time the Department of Education was a dubious venture. She alleged lurid details about her time with Thomas in the Education Department, claiming that he had spoken about acts that he had seen in pornographic films involving such matters as women having sex with animals and films showing group sex or rape scenes. On several occasions, he had allegedly told her graphically of his own sexual prowess. And once in the Equal Employment Opportunity Commission, he had been drinking a Coca-Cola in his office, and then he had got up from the table where they had been working, had gone over to his desk to get the Coke can or glass, then had looked at the can, okay, it was a can, and had asked, "Who has put pubic hair on my Coke?" Two women, Angela Wright and Rose Jourdain, had made statements to the Senate staffers in support of Hill. Ultimately, however, they were dismissed by the Judiciary Committee without testifying. Wright, who had been one of Thomas's subordinates in the Equal Employment Opportunity Commission, or Equal Economic Opportunity Commission, sorry, until he had dismissed her, had told Senate Judiciary Committee staff that Thomas had repeatedly made comments to her much like those he allegedly had made to Hill, including pressuring her for dates, asking her the size of her breasts, and frequently commenting on other women's anatomy. Rose Jourdan had said that Wright had spoken to her about Thomas's statements at the time when they had allegedly been made, and that Wright had become increasingly uneasy around Thomas because of his constant commentary about her body and looks, and that Wright had once come to Jourdan's office in tears as a result. Another former Thomas assistant, Sukari Hardnett, did not, interestingly enough, accuse Thomas of sexual harassment, but told the Judiciary Committee staff that if people were young, black, that is African American, female, reasonably attractive, and worked directly for Clarence Thomas, they must have been fully aware that they were being inspected and auditioned as females. Thomas categorically denied Hill's testimony, claiming, "I deny each and every single allegation against me today that suggest in any way that I had conversations of a sexual nature or about pornographic material with Anita Hill, that I ever attempted to date her, that I ever had any personal sexual interest in her, or that I in any way ever harassed her." He went on to say, "This is not an opportunity to talk about difficult matters privately or in a closed environment. This is a circus. It's a national disgrace, and from my standpoint, as a black American, it is a high-tech lynching for uppity blacks, in other words, African Americans who want to rise socially, who in any way deign to think for themselves, to do for themselves, to have different ideas, and it is a message that unless you kowtow to an old order, this is what will happen to you. You will be lynched, destroyed, caricatured by a committee of the United States Senate, rather than hung from a tree." Several witnesses testified in support of Clarence Thomas. For example, J.C. Alvarez, a woman who for 4 years was Thomas's special assistant in the Equal Economic Opportunity Commission. She said that the Anita Hill she had known before had been nobody's victim. She also claimed that Thomas had demanded professionalism and performance, and that Thomas had not tolerated the slightest hint of impropriety, and everyone had known it. Also, Nancy Fitch, a special assistant historian to Thomas in the Equal Economic Opportunity Commission, claimed that all of Hill's allegations against Thomas were false. So did Nancy Altman, who had worked with Hill and Thomas in the education department. Despite the controversy, Thomas was confirmed. He's associated with the US Supreme Court's more conservative side. And just like the unsuccessful Supreme Court nominee Robert Bork, he believes in a strict interpretation of the US Constitution and in judicial decisions that try to approximate the US Constitution's author's original intentions. On average, from 1994 to 2004, Scalia and Thomas had an 87% voting alignment, the highest on the court, followed by Ginsburg, Ruth Bader Ginsburg, and David Souter, 86%. From 1994 to 2004, on average, Thomas was the third most frequent dissenter on the court behind Stevens and Scalia. John Stevens had been appointed by the late US President Gerald Ford in 1975. Thomas spoke favorably about the concept of stare decisis, or standing by precedent, during his confirmation hearing, stating that stare decisis provides continuity to our system, it provides predictability, and in our process of case-by-case decision-making, I think it is a very important and critical concept. He has argued that the executive branch has broad authority under the Constitution and federal statutes. When the late William Rehnquist was the U.S. Supreme Court's Chief Justice until his death in 2005, and Thomas was already serving as an Associate Justice on the Supreme Court, he consistently voted for outcomes that promoted state governmental authority in cases involving federalism-based limits on the U.S. Congress's enumerated powers. Among the 9 justices, Thomas was, as of 2002, the second most likely to uphold free speech claims, tied with David Souter. In the McDonald versus Chicago decision in 2010, he agreed that the right to keep and bear arms is applicable to state and local governments. However, he wrote a separate concurrence finding that an individual's right to bear arms is fundamental as a privilege of American citizenship under the Privileges or Immunities Clause rather than as a fundamental right under the Due Process Clause. In cases regarding the Fourth Amendment that prohibits unreasonable searches and seizures, Thomas often favors police over defendants. In Doggett versus the United States, the defendant had technically been a fugitive from the time he was indicted in 1980 until his arrest in 1988. The court held that the delay between indictment and arrest violated Doggett's Sixth Amendment right to a speedy trial, finding that the government had been negligent in pursuing him and that he was unaware of the indictment. Thomas, however, dissented, arguing that the purpose of the speedy trial clause was to prevent undue and oppressive incarceration, and that the anxiety and concern accompanying public accusation and the anxiety and concern accompanying public accusations, and that this case implicated neither. Regarding capital punishment, and this relates to the Eighth Amendment, according to which there will be no cruel and unusual punishments inflicted on anyone in the United States. Thomas was among the dissenters in Atkins versus Virginia and Roper versus Simmons, which held that the Eighth Amendment to the United States Constitution prohibits the application of the death penalty to certain classes of persons. In Hudson versus Macmillan, a prisoner had been beaten, garnering a cracked lip, broken dental plate, loosened teeth, cuts and bruises. Dissenting, Thomas wrote that, in his view, a use of force that causes only insignificant harm to a prisoner may be immoral, it may be tortious or tortuous, it may be criminal, and it may even be remediable under other provisions of the federal Constitution, but it is not cruel and unusual punishment. In concluding to the contrary, the court today goes far beyond our precedents. He believes that the Equal Protection Clause of the 14th Amendment forbids consideration of race, such as race-based affirmative action or preferential treatment. He has contended that the Constitution does not address the issue of abortion. In Romer versus Evans in 1996, Thomas joined Scalia's dissenting opinion, arguing that Amendment due to the Colorado state constitution did not violate the Equal Protection Clause of the 14th Amendment to the U.S. Constitution. The Colorado Amendment forbade any judicial, legislative, or executive action designed to protect persons from discrimination based on homosexual, lesbian, or bisexual orientation, conduct, practices, or relationships. He has written to date, or published to date, 4 books. My Grandfather's Son, a memoir, 1 book, and then 3 major law articles. Why Federalism Matters, Drake Law Review in 2000, Supreme Discomfort, The Divided Soul of Clarence Thomas, and Punishment and Personhood, published in City Journal in 1994.